The Committee on House Administration will come to order. I note that a quorum is present, and without objection, the chair may declare a recess at any time. Also, without objection, the meeting record will remain open for 5 legislative days, so members may submit any materials they wish to be included therein. Today, we will be having Congressman Mike Johnson joining us, and he has waived onto the committee to participate in today's hearing. I thank Ranking Member Morelli, members of the committee, and our witnesses for joining today's Americans' Confidence in Elections hearing on the importance of political speech. Political speech is protected speech. Our founding fathers enshrined the First Amendment in the Constitution. Unfortunately, in our highly politicized political culture and climate, the First Amendment has been under attack through the use of misinformation czars and cancel culture. As a result, many Americans have grown concerned that their voices will be suppressed or that their beliefs will be weaponized against them. That's exactly what we saw 10 years ago, nearly to the day when the now infamous scandal of the IRS involving then acting director of exempt organizations, Lois Lerner. On May 10, 2013, the IRS had to apologize to conservative organizations for inappropriately targeting their applications for tax-exempt status. The federal government admitted to targeting a group of people because of their political beliefs. This is un-American and anti-democratic. Over a decade later, we're still having conversations about the weaponization of the IRS and DHS, the need to protect donor privacy, and other free speech and freedom of association issues. I'm committed to upholding America's First Amendment right to support candidates, causes, organizations of their choice without fear or retribution. That's why I'm focused on introducing the American Confidence in Elections Act, or the ACE Act. The ACE Act is our federalist approach to bolster election integrity and voter confidence, which in turn boosts voter participation. One thing we can do to build voter confidence is prevent another Lois Lerner scandal from occurring. The ACE Act will finally prohibit the IRS and any other federal agency from asking for an organization's donor list, creating ad hoc standards, and applying them to ideologically opposed groups. This will help to protect individuals from retribution, harassment, or intimidation based on their beliefs. In addition to protecting donor privacy, the ACE Act will also bring greater transparency and accountability into the federal campaign finance system. Last Congress, every single House Democrat voted to allow federal funds to be used towards their political campaigns. The ACE Act will specifically prevent this from happening. It also encourages federalism by strengthening state political parties. Instead of being centers for voter organization and messaging, state parties are currently some of the most highly restricted organizations in our system. Voters already think our political parties can work directly with their candidates with few restrictions, Republican parties with Republican candidates, the Democratic Party with Democratic candidates. But in reality, the outdated campaign finance system means that there's all sorts of hoops to jump through for this simple political process to work as expected. In many ways, it doesn't make sense. Making the law work as voters expect will increase transparency in the campaign finance system, which will boost voters' confidence in our elections. As we begin today's hearing, I look forward to discussing some of these provisions and identifying what additional campaign finance reforms and donor privacy protections are necessary in restoring voter confidence. I will also note that John Sarbanes will also be waived on to this committee in recognition of a request by the minority. I thank you for participating. I now recognize Ranking Member Morelli for 5 minutes for the purpose of making his opening statement.
Good morning. Thank you all for being with us. Thank you, Chairman Stile, for welcoming us all today. Supreme Court Justice Louis Brandeis famously said over a century ago, sunlight is said to be the best of disinfectants. This observation, supporting transparency and good governance, remains true today. Transparency about who is seeking to influence federal elections is critical to democratic self-governance. Yet a common refrain from our colleagues on the other side of the aisle is that campaign finance laws, and disclosure laws in particular, have an unlawful chilling effect on political speech. I would find this a baffling argument if it were not for my suspicion that it is rooted in cynicism. A central aim of the Constitution is to ensure meaningful self-government by the citizens. The First Amendment protects the right to engage in the public sphere. Disclosure laws don't silence speech, they simply ask you to stand by it. You don't have to have a law degree to understand this fundamental principle. But in its campaign finance decisions, the Supreme Court, comprised of folks who do have law degrees, has repeatedly acknowledged the connection between political transparency and democratic self-governance. In 1976, Buckley versus Vallejo recognized that disclosure, quote, provides the electorate with information as to where political campaign money comes from and how it is spent by the candidate in order to aid the voters in evaluating those who seek federal office. Aiding the voters in evaluating those who seek federal office, end quote. Similarly, in 2010, Citizens United versus the FEC described how disclosure promotes self-governance by supplying information that, quote, enables the electorate to make informed decisions and give proper weight to different speakers and messages. Indeed, while Citizens United supercharged dark money in American elections, the decision held by an 8-to-1 vote that campaign disclosure rules are not only constitutional, they are preferred to many other forms of regulation. Justice Clarence Thomas, however, parted ways with even his fellow conservative justices when it came to the law's disclosure requirements, casting the lone dissenting vote. Given recent reporting, Justice Thomas's allergic reaction to transparency and disclosure is no surprise. He has failed for years to disclose lavish gifts from Harlan Crow, a wealthy conservative donor. Those gifts include luxury vacations, tuition for a grandnephew at a private boarding school, and even the purchase of the justice's mother's house, where she remains able to live free of charge. Justice Thomas's personal decisions to receive such lavish gifts without reporting them publicly are a quintessential example of why we need disclosure. Another example is the just unsealed 13-count indictment against Representative George Santos. According to the indictment, Representative Santos engaged in a fraudulent scheme to solicit large donations to a fictitious 501c4 organization and a super PAC. This scheme's fraudulent premise is the product of our post-Citizens United era, where wealthy special interest donors try to call the shots. I would repeat my call for his resignation. A remedy to this onslaught of dark money is disclosure. The Supreme Court has consistently recognized that disclosure laws enhance, rather than constrain, the free speech necessary to sustain our democracy. The Court has opined that disclosure laws directly serve the democratic values animating the First Amendment, quote, securing the widest possible dissemination of information from diverse and antagonistic sources and facilitating uninhibited, robust, and wide-open public debate. In another 8-to-1 decision, again with Justice Thomas dissenting, we see a pattern here, the Supreme Court upheld the disclosure of referendum petitions. Rejecting requests for anonymous political speech, Justice Antonin Scalia, that noted progressive bulwark, observed that he does not look forward to society which, thanks to the Supreme Court, campaigns anonymously, hidden from public scrutiny, and protected from the accountability of criticism. He famously said that such a future does not resemble the home of the brave. I agree with Justice Scalia. House Democrats will continue advancing pro-voter, pro-transparency measures and bills like the Freedom to Vote Act, Disclose Act, and Honest Ads Act among them. Strong disclosure requirements can help educate voters about candidates, policies, and sources of political speech, promoting informed decision-making in the electoral process, everything we should want in American elections. Likewise, disclosure provides the public with information to monitor elected leaders and hold them accountable. For that reason, there is also work to be done to advance stock trading reforms and the need to pass reforms that strengthen disclosure around conflicts of interest in our own House and in the courts. Transparency measures that inspire confidence in voters and confidence in the American public. And I would also note, American taxpayers under our bill will not pay a single penny to fund the campaigns of candidates participating in the small donor system. They are surcharges on fines. They are not paid for by the American taxpayer, despite repeated suggestions that that's not the case. And let me, before I close, I seek unanimous consent that the unsealed 13-count indictment against Representative Santos be entered into the record. I also ask unanimous consent that a New York Times piece published yesterday by David Firestone titled George Santos' Spectacularly Dumb Alleged Scheme, which highlights the consequences of the post-Citizens United era, notably deregulation and under-enforcement of our campaign finance laws, be added to the record. With that, I thank you, Mr. Chairman, and I yield back.
Without objection, so ordered. The gentleman yields back. All other members' opening statements will be made part of the hearing record if they're submitted to the committee clerk by 5 p.m. today. Pursuant to paragraph B of Committee Rule 6, the witnesses will please stand and raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Let the record show that the witness answered in the affirmative and may be seated. I'll now introduce our witnesses. Our first witness is Ms. Harmeet Dillon, is a nationally recognized lawyer with a passion for justice, a zeal for attacking legal challenges, and an intense sense of satisfaction in helping our clients realize creative and practical solutions to seemingly intractable problems. From an early interest in constitutional litigation to a stint at the Department of Justice, a decade of practice at prestigious international law firms, and founding her own firm in 2006, Ms. Dillon has developed a niche practice in representing clients across California in election and campaign finance law matters. In addition, Ms. Dillon is the founder and chief executive officer of the Center for American Liberty, a nonprofit organization dedicated to defending the civil liberties of Americans. Our next witness is Ms. Audrey Perry Martin, a national and California political law expert with over 15 years of experience, who currently serves as partner of the Gober Group's Sacramento office. Ms. Martin has extensive presidential election campaign experience, serving as FEC counsel for the McCain-Palin campaign, deputy general counsel for the Romney for president, and a consultant on the 2012 campaign. Between 2005 and 2006, Ms. Martin also served as legal counsel to the Committee on House Administration, where she focused on issues such as HAVA implementation, election integrity, congressional ethics, and campaign finance. Our next witness, Mr. Justin Reamer, is principal at Reamer Law and has been advising clients and high-ranking public officials on election administration, voting rights, and campaign finance matters for nearly 50 years. Previously, Mr. Reamer served as chief counsel of the Republican National Committee and as counsel to the U.S. Senate Committee on Rules and Administration. Mr. Reamer also served as deputy secretary of the Virginia State Board of Elections, where he's coordinated implementation of the 2011 redistricting process, the administration of the 2012 presidential election, and the 2013 gubernatorial elections, which included a statewide recount for Attorney General. Our next witness, Mr. Bradley Smith, is the chairman and founder of the Institute for Free Speech and previously served as chairman for the Federal Election Commission. As an FEC commissioner, Mr. Smith was praised for his integrity and refusal to put partisan interests ahead of his duties, as well as his steadfast support for free speech. Mr. Smith currently serves as the Josiah H. Blackmore Shirley M. Null Designated Professor of Law at the Capital University Law School in Columbus, Ohio. I'll also note that's a heck of a long name. And finally, Mr. Stephen Spaulding is the Vice President for Political and External Affairs at Common Cause. Mr. Spaulding has served in senior staff positions on Capitol Hill in both the House and Senate, most recently as the Policy Director for the U.S. Senate Rules Committee, where he advised his chair, Senator Amy Klobuchar. In addition, Mr. Spaulding was previously the Senior Elections Counsel to the Committee on House Administration under the leadership of Chairwoman Zoe Lofgren. We appreciate all our witnesses being here today and look forward to your testimony. As a reminder, we've read your written statement, and it'll appear in full in the record. Under Committee Rule 9, you're to limit your oral presentation to a brief summary of your written statement, unless I, in consultation with Mr. Morelli, extend that time. Please remember to switch on your microphone in front of you so that the members can hear you. When you begin to speak, the light in the timer will turn green. After 4 minutes, it'll turn yellow. When the red light comes on, we'll ask you to wrap it up. I now am honored to now recognize Ms. Harmeet Dillon for 5 minutes for the purpose of making an opening statement.
Thank you. Good morning, Chairman Stile, Ranking Member Morelli, and members of the committee. I appreciate your invitation to testify today on a topic that I believe to be an existential threat to our democracy and corrosive to our core values as a nation. I'm referring to the pervasive coordinated efforts between our government and private actors to influence the outcomes of our elections. Whether in my role as chairman of the Center for American Liberty, chairman of the Republican National Lawyers Association, or representing 5 million California Republicans at the Republican National Committee, it's probably the #1 thing that citizens want to learn more about and do something to stop. I'd like to address 2 separate but related examples of the ever-expanding public-private alliances directly impacting public trust in American elections. First, the expanding government efforts to censor core political speech online, and second, the increasing use of private funds to run public election operations. Reporting over the last year has revealed the extensive coordinated efforts between government actors, big tech, nonprofits, and academics to identify and censor what they collectively deem to be, quote, misinformation. What we know about the scope of this government-dictated and privately facilitated speech-killing machine is truly staggering, and we certainly don't know the full picture yet. An Intercept article by Ken Klipperstein and Lee Fang reported that the Department of Homeland Security made combating election misinformation a top priority. The article describes the formalized process that social media platforms, including Facebook, Instagram, and Twitter, created in the 2020 election, allowing government officials to quickly flag content for removal, and a vast network of nonprofit organizations working in concert with the federal government and social media companies to police online speech. There's also a Missouri-Louisiana lawsuit filed by then Attorney General Eric Schmidt and Attorney General Jeff Landry. The allegations rely on extensive documentation that describes at a granular level how private social media platforms, hand in hand with government officials, work together to define and then suppress so-called misinformation. The Twitter files reporting by Matt Taibbi, Michael Schellenberger, and others, certainly not conservative journalists, revealed extensive coordination with the FBI and other federal agencies. They aided the intelligence community in its work overseas, and they reveal extensive shadow banning to limit certain opinions that are disfavored by the government. Twitter relied on government actors and nonprofit partners to identify the speech it then chose to censor. I've experienced this in my law practice. Our client, Rogan O'Hanley at the Center for American Liberty, was a victim of government censorship in the 2020 election. The posts that he was censored for were core political speech about an election that are protected by the First Amendment of the United States Constitution. The censorship campaign was led by a state agency with a mission to identify and censor government-labeled misinformation, and then not only suppress the speech, but silence the speaker himself from speaking on social media. The state coordinated with a partisan consulting firm, SKD Knickerbocker, which was also a consultant to the Biden campaign, to help with its efforts. The state coordinated with the National Association of Secretaries of State to develop a special process for notifying social media companies what speech it should censor and remove from the internet. Communications Decency Act, Section 230, has also had a major impact on censoring speech online. 230's traditional editorial function test has been repeatedly misinterpreted by federal courts to protect social media platform censorship online. The statute has been weaponized by big tech to fend off lawsuits by those who've fallen victim to coordinated censorship campaigns like Mr. O'Hanley. Congress should act to clarify Section 230 to ensure that it does not protect discriminatory censorship practiced by the big tech companies, whether in concert with government agencies or not. A lack of private cause of action against big tech for discriminatory censorship is a gap in our free speech regime, and it does threaten confidence in elections. In conclusion, I'm going to talk about Zuckerbucks. States are grappling with the phenomenon of so-called Zuckerbucks. This is a shorthand reference to private entities and individuals injecting hundreds of millions of dollars into local election administration, battleground precincts, that often determine the outcomes of important races. It had a major impact in the 2020 election, with 2,500 election offices across the country receiving grants in varying amounts from CTCL and CEIR, both funded by Zuckerberg-Chan Initiative. While a handful of state legislatures have taken action to ban Zuckerbucks, many governors have vetoed these measures. Distrust in elections is not a partisan issue. Both Republicans and Democrats today have expressed a historic level of distrust in our elections, and I hope that a renewed commitment by Congress to protecting freedom of speech in elections will help alleviate that trend and increase public confidence in America's elections. Thank you very much.
Thank you, Ms. Dillon. I now recognize you, Ms. Audrey Perry Martin, for 5 minutes.
Good morning. Thank you, Chairman Stile and Ranking Member Morrell, for having me today. I appreciate this opportunity to talk about the critical importance of protecting political speech in U.S. elections. I want to focus my comments today on the necessary and primarily nonpartisan modernization changes outlined in Section 3 of the ACE Act, and the importance of updating federal campaign finance laws to put them in line with our modern era. Although campaign finance policy is the subject of intense debate and public interest, current federal campaign finance laws are woefully outdated. Significant changes have occurred in campaign finance policy, in technology, and in the political landscape since the last time Congress passed a substantial amendment to the Campaign Finance Law over 20 years ago with the Bipartisan Campaign Reform Act, or BICRA. Since 2002, Congress has only made really minor changes to federal statutes. Although the Federal Election Commission has attempted to fill this gap with regulations, many provisions of the Federal Election Campaign Act of 1971, or FECA, need modernization to keep the law in line with current political realities. First, most campaign finance reports filed with the Federal Election Commission, or the FEC, are required to be done electronically for anyone who's raising or spending over $50,000. However, electioneering communication reports are not currently required to be filed electronically. This doesn't make a lot of sense in our modern era. Reports that are filed electronically are available much sooner to voters, and it's a lot easier for staff to process them. Second, the lack of legislation focused specifically on online campaign activity has led to much uncertainty in the regulated community about how to report communications made over the internet and what type of disclaimers are required for internet political ads. This issue has not just affected campaigns and political committees. Private citizens expressing their opinion over the internet can unknowingly run afoul of federal campaign finance laws by expressing their political views online. As a result, it's been left to the FEC to attempt to modernize these rules through the regulatory process. Although somewhat helpful, this regulation did not address several important issues. The ACE Act addresses most of these issues. The bill codifies the FEC's 2006 internet rulemaking by exempting unpaid internet communications from the definition of a contribution and expenditure, even when they're coordinated with a candidate. Furthermore, the ACE Act expands the media exemption to include electronic and internet-based news companies, clearing up confusion over which companies were eligible for the exemption. Under this act, a news organization that's not owned or controlled by a party, a political committee, or a candidate should qualify for the media exemption. These technical amendments to the FECA are needed to modernize the law for the current era. Third, the proposed bill updates the law to align with inflation. Under FECA, certain contribution limits are indexed for inflation every 2 years based on the change in the cost of living. However, not all of them are, and FECA does not tie the qualifying threshold for political committee qualifications. So rapid inflation in the past decades resulted in an extremely low qualification threshold for filing reports with the FEC. For example, under current law, an entity will become a political committee after spending only $1,000 to support a candidate. And this isn't indexed for inflation, so every year it gets worse. The proposed bill addresses these outdated limits by increasing them and tying the qualification thresholds to inflation, avoiding the need for Congress to address this again in 20 years. This would help avoid chilling grassroots political speech by setting too low of a trigger to qualify as a committee or to file FEC reports. Finally, Section 3 of the ACE Act includes several additional significant nonpartisan changes. It implements the FEC legislative recommendations to make permanent the extension of administrative fines for qualified disclosure requirement violations, which for years has just been extended temporarily. It raises the annual rate of pay for staff and adjusts it for inflation in the same manner as other positions in the executive schedule, allowing the FEC to attract and retain qualified employees. It also clears up the rules regarding what happens if a candidate dies and no one's at the helm of the campaign. It codifies recent Supreme Court decisions, simplifies joint fundraising, and sunsets the unused presidential public funding program. Current federal campaign finance laws need to be updated and require modernization to keep up with the changing political and technological landscape of our day. The modernizing sections of the ACE Act are a critical update to federal election law to address these important issues.
Thank you, Ms. Perry Martin. I now recognize Mr. Justin Reamer for 5 minutes.
Thank you, Mr. Chairman, members of the committee. I'm grateful for the opportunity to discuss overdue reforms to help strengthen our nation's local and state political parties. As former chief counsel to the RNC, I saw firsthand how campaign finance restrictions are hollowing out our state parties. This is bad for our political system, but fortunately, even modest reforms can provide meaningful relief, ensure better legal compliance, and decrease political polarization. BICRA weakened our local parties by choking off their ability to fundraise and engage in grassroots political programs, and saddling them with Byzantine regulations. Don't take my word for it. Experts from across the ideological spectrum note both the positive role parties play in our system and how BICRA weakens them. A few suggestions on how Congress can help. First, state parties have suffered because their ability to fundraise has steadily eroded since the enactment of BICRA in 2003. This is due to Congress's failure to index for inflation when setting state party contribution limits, even though it did do so for national parties and federal candidates. State parties today are stuck with the same $10,000 contribution limit they were in 2003. Not indexing for inflation means that a $10,000 contribution made in 2003 is worth just over $6,000 today. For comparison, in 2003, the national party committees had $25,000 limits, and today they are over $41,000. BICRA left state parties behind at the same time the law imposed other fundraising and spending restrictions. Meanwhile, campaign costs have increased even when accounting for inflation due to numerous factors, including increased early and mail voting. Yes, the emergence of super PACs has contributed to increased spending and helped reduce parties' influence, but their inability to remain competitive preceded Citizens United. Congress should raise state party limits and account for inflation, or these disparities will only grow worse. There's little downside since state parties are also one of our most transparent political entities. There is another reform that would help. State parties are permitted to have separate state election accounts, which in theory should help them remain competitive. But BICRA's federalization of our elections has made these accounts largely irrelevant. BICRA requires state parties to fund most of their activities in federal election years from their already inflation-depleted federal accounts. This includes voter registration drives and basic get-out-the-vote activities that don't even reference a federal candidate. Thus, a state party with few or no competitive federal races, but several state and local ones, must use only federal funds, even if they are flush with state dollars. Compliance with these regulations is also difficult. State parties are the most regulated political entities in our system because they have to comply with both state and federal campaign finance laws. And ironically, BICRA made things the most complicated for the least resourced political committees. It's hard to fathom how any of this prevents corruption, and in practice, it only stifles parties' ability to engage in core First Amendment protected speech and time-honored grassroots activities. It's common sense to reduce these regulatory burdens by not only raising contribution limits, but also giving state parties flexibility in financing these grassroots activities. 2022's ACE Act would have done just that by exempting certain state party functions from federal regulation so long as they were not coordinating with candidates. Finally, another overdue reform would be to increase the spending threshold for when local grassroots organizations must register and report to the FEC. For example, groups must do so if they spend more than $1,000 in supporting federal candidates in a year. Like the state party limits, this threshold has remained static and unindexed for inflation, in this case since the early 1970s. Compliance is also unrealistic. I'm sure there are dozens of local groups out there that have unwittingly triggered these limits and have not reported, nor can the FEC police enforcement. No wonder both Democrat and Republican FEC commissioners have consistently called on Congress to raise those limits and index them. This would avoid entrapping local groups that raise and spend comparatively little, but are still important participants in our political process. These are all seemingly technical issues in the overall campaign finance landscape, but I can assure you as a practitioner in this area, they are important. State and local parties are essential to our political system. Not only do they allow Americans to come together and exercise their First Amendment rights, they are also instrumental in nominating and electing our future office holders. Even the Brennan Center, an organization I rarely agree with, noted in its call to ease these burdens that parties in it are an essential element of our democracy and a moderating force responsive to public opinion. Easing regulatory burdens on them will not solve all of their problems, but it will give them a fighting chance. Thank you.
Thank you very much, Mr. Reamer. Mr. Bradley, I understand your flight just made it in on time, so we appreciate you hustling to be with us today. You are now recognized, Mr. Smith, for 5 minutes.
Thank you, Chairman Stile and Ranking Member Morelli, members of the committee. Campaign finance is fundamentally different from most government regulation in the sense that it concerns the heart of democratic self-governance, when and how we discuss issues of public policy and public affairs and candidates for office. For that reason, the Supreme Court has noted that the First Amendment has its fullest and most urgent application precisely to the conduct of campaigns for political office. But I would add to that broader discussion, again, of public affairs and issues. The government should not constrain the right of the American people to discuss candidates and politics lightly. The Supreme Court has recognized only one permissible grounds for restricting speech, political speech, and that is the prevention of quid pro quo corruption or its appearance, and constantly rejected attempts to restrict campaign speech based on other legislative aims. The ASEC legislation should begin, as it does, by modernizing the disclosure regime and simplifying regulation. In the 2022 midterms, the average candidate for the U.S. Senate raised about $13.8 million. The average candidate for the U.S. House about $1.8 million. On top of this, you have about $7.4 billion spent by federal political action committees and another $1.1 billion by independent expenditures. In order to prevent people from improperly influencing candidates, contributions are limited to $3,300 per election. But any group of people that bands together to talk with the major purpose of defeating one or more federal candidates or electing one or more such candidates and spends more than $1,000 is required to register and file burdensome reports with the Federal Election Commission. Anyone spending money to independently try to elect or defeat a federal candidate has to file at just $250. Now, to the average citizen, even $250 seems like a pretty good chunk of change, let alone $5,000 that a group might contribute as a PAC. But in the context of a $1.8 million House campaign, it's hard to envision that this has any corrupting effect on the members of this committee or their colleagues in the House. And these numbers, we should note, have not been adjusted even for inflation since the 1970s, these numbers on disclosure, which includes donors of as little as $200. Now, free societies thrive on the public exchange of ideas. The First Amendment protects not only the brave, but it also protects the meek, the weak, and minorities of all kinds. For example, today we see people often publicly hounded for their association with groups, sometimes years in the past, that have for one reason or another become controversial. I'll just give one high-profile example, but I could give many others, including examples of people who we would view as much more ordinary citizens. But a high-profile example would be California's Proposition 8, which passed in 2008 in California, a very liberal state, representing over the votes of over 7 million people. Now, whether one agrees with the proposition or not, it was hardly outside of mainstream political discourse in 2008. Yet nearly 6 years later, Mozilla CEO and founder Brendan Eich was pressured into resigning from his company due to the controversy surrounding a small contribution of $1,000 he had previously made supporting Proposition 8, again, close to a decade before. If anything, our political culture is becoming more unforgiving in the decades since Mr. Eich's resignation. And faced with this minefield, many people will simply refrain from supporting political or policy groups rather than risk the backlash that may come years later. So these low reporting thresholds and excessive reporting requirements chill protected speech. Now, we should also note that disclosure of public debate has been sanctioned by the Supreme Court, but the Supreme Court has never sanctioned disclosure of anything related to public affairs or political issue discussion. It has only sanctioned disclosure in the context of political committees, that is, organizations that exist for the primary purpose of electing or defeating candidates for office, or for speech which is expressly advocating the election or defeat of those candidates or its functional equivalent. And talk about dark money seems to hide this. We should note that so-called dark money consists of well under 5% of total spending in federal political races, and most of that dark money is, in fact, relatively well known to people. For example, large dark money groups identified as dark money groups, include the National Resources Defense Council, the National Association of Realtors, the U.S. Chamber of Commerce. I don't think that most Americans are scratching their heads desperately trying to figure out what the U.S. Chamber of Commerce or the National Resources Defense Council stands for. So in the end, I think ASEC makes good steps. One thing that I would emphasize here as I conclude is that it is important for ASEC to get out of the campaign finance regulation business. Other agencies, such as the Internal Revenue Service, which led to the Tea Party scandal, the SEC or the FCC, and leave this to the agency designated by statute to interpret campaign finance law, the FEC. Thank you for your time. I look forward to your questions.
Thank you very much, Mr. Smith. Mr. Spalding, you're now recognized for 5 minutes.
Good morning, Chairman Stile, Ranking Member Morelli, distinguished members of the committee. Thank you for the opportunity to be here this morning. Our North Star must be a democracy that lives up to its promise, one where everyone participates and everyone is heard. It's why we have the freedom to vote. The late, great American hero, Representative John Lewis, said it best. It is the most powerful nonviolent tool we have in a democratic society. The freedom to vote is political speech. It's the power to have a voice in our democracy. And political speech has been under attack. Voter suppression, gerrymandering, and the undue influence of big money in politics form a trifecta that silences voters. Today we're focusing on money in politics. The Supreme Court's decisions in Citizens United and McCutcheon ripped a massive tear in the fabric of laws that Congress passed to stop corruption and bring transparency to our elections. Just 100 people, enough to fit into this hearing room, contributed nearly 3/4 of the $1.2 billion people contributed to super PACs in the last cycle. Put another way, 100 people pumped 60% more money into our elections than millions of small donors combined. And this money is coming from a tiny and highly unrepresentative segment of the public, and Americans have good reason to think that their voices are being drowned out. And it's made worse because much of it is undisclosed. Since Citizens United, according to the nonpartisan Open Secrets, at least $3 of every $10 in outside spending reported to the FEC since Citizens United can be traced to dark money groups. Justice Kennedy wrote in Citizens United in a provision to the opinion that had the support of 8 out of 9 justices that, quote, disclosure enables the electorate to make informed decisions and give proper weight to speakers and messages and lets voters make informed choices in the political marketplace. So transparency in campaign spending protects voters' right to know who is speaking to them and who is trying to influence their votes on Election Day, and so that they can give proper weight to different speakers and messages, as Justice Kennedy wrote. It stops corruption, and it makes sure we can enforce our campaign finance laws in the first place. Consider a scandal that has rocked Ohio. Imagine you're an executive at a power company on the verge of bankruptcy. If you can spend the company's money to elect some hand-picked candidates to the State House, including the Speaker of the House, you have a good chance of securing an eye-popping return on your investment, like a $1 billion bailout of 2 of your power plants. One of your lobbyists slips a $400,000 check across the table to further the scheme made out to the dark money group controlled by the future speaker. This isn't just made up. In March, a former speaker of the Ohio House of Representatives was convicted in a racketeering trial that involved $60 million in bribes in exchange for a $1.3 billion power plant bailout. Ohioans could not follow the money to get to the root of the scandal. And it doesn't have to be this way, and it's solvable, and there's momentum in the states. Take Arizona. Just last fall, voters there approved the Voters' Right to Know Act by a vote of 72% to 27% in Arizona, so that Arizonans can see who is behind big campaign spenders there. The House has passed the Disclose Act several times to shine a light on secret money in elections. It's also passed the Bipartisan Honest Ads Act to help voters know who is behind political advertisements they see online. And of course, these were all passed as part of the Freedom to Vote Act, a bill that puts people first. They stand in sharp contrast to the ACE Act as introduced last Congress. Provisions in the ACE Act would open the door to more secret money in our elections and further empower the wealthy few to spend even more money purchasing access and influence. You know, the other day I was looking at the most recent turnout statistics that came out from the Census Bureau. About half of eligible voters sat out the election last year. And in 2020, a high watermark for turnout, roughly 1/3 of eligible voters sat it out. So their political speech went unspoken at the ballot box. So as we hold ourselves out as democracy's gold standard, we have to do more to ensure that everyone can participate and everyone can be heard, where our government is representative and reflective and responsive to the people that it serves. That's what will strengthen confidence in elections and vindicate the most fundamental freedom that we have, the freedom of one person, one vote. Thank you, Chairman Stile.
Thank you very much, Mr. Spalding. I'll now recognize Mr. Griffith for 5 minutes for the purpose of asking the witnesses questions.
Thank you, Mr. Chairman. I greatly appreciate that. I'll ask this to all witnesses today. It's almost 10 years to the day after the fateful announcement by Lois Lerner of the IRS that the agency was disfavoring groups when granting tax-exempt status. While Congress has passed language on a bipartisan basis each year since 2013 to prevent another Lois Lerner situation, it's time to make those protections permanent. Would you agree? Start with you, Ms. Dillon, yes or no?
Yes, sir, I do agree.
Ms. Martin?
I do agree, yes.
Mr. Raymer?
I do, yes.
Mr. Smith? Mr. Spaulding?
501c4s should not be vehicles for dark money in our elections.
So you agree?
Well, I agree that 501c4s have been abused, particularly after Citizens United, to
Do you
form dark
agree or
money arms
disagree?
of
I'm just trying to get a
super
yes or no.
I believe that 501c4s
So I'm
have
gonna
an
take that as a
important
no
role to
unless you-
play to promote social welfare.
Unless you say
Not-
yes, I'm
but
taking it as a no,
they-
okay?
What they shouldn't be
All right.
is
I-
avenues to cloak dark money
I'll
and
move on
spending.
to the
They need
next question.
They should be promoting social welfare.
Mr. Raymer, I'm going to agree with you because you said it in your opening statement, but I had it written down as a question, so I'm going to rearrange it a little bit. But state parties are the most highly regulated organizations in the political sphere. We have so severely limited how they can operate that in some states they barely exist. And I agree with you that we should remove restrictions on state parties that don't make sense and put state parties on a solid footing to be able to organize voters and support their candidates without the heavy weight of the federal government. And I say that having been a 17-year member of the Virginia State Central Committee of the Republican Party. And so, I saw a lot of this happening over time. That being said, I note in the ACE Act, so I'd like to get your thoughts on this, that it looks like even in the ACE Act, the penalties are higher on a state and local party that violate the rules, but the penalties are higher than they are on a foreign national who violates the rules. Do you think that's right?
And I'm not familiar with that particular provision, Congressman, but I mean, the fact of the matter is these state and local organizations have a hard enough time paying any FEC enforcement fees or anything like that. I mean, it's very difficult for them. They don't have much money to begin with. And so I think the punishment should be reflective of the infraction. And I think oftentimes it's not.
And I think that's true, and I think you touched on this in your opening as well. A lot of times, particularly with the local party officials, they're just doing the best job they can. That doesn't mean that there shouldn't be some kind of a sanction if they violate the rules, but it ought to be rational and based on what their mental state was and whether or not it was something they were doing to play games, to try to do things they weren't supposed to do, or whether it was a mere fact that they just didn't understand and it was confusing. And I think you stated, and you can elaborate more, that we need to make these laws and rules related to local and state parties easy to understand so they don't inadvertently cross some tripwire.
Absolutely, Congressman. As I've mentioned, the state parties are the most regulated entity, and they have to deal with this sort of Venn diagram of federal and state law and having to comply with both. And at the RNC, we really don't have to do that. We're basically a federal committee, and it's regulated by federal law, but the states have to deal with both. And even where those two things come together, there's all sorts of blurry lines, and it's almost impossible for them. And I can tell you that in dealing with dozens of state and local parties over the years, that any FEC issues that I have seen, non-compliance or whatever, have been out of maybe a lack of sophistication, inability to hire expert compliance people, attorneys to get them through this stuff. It's difficult.
And that's why I suspect you would favor having a legal fund for the state parties and a building fund, one, so that they can be better educated and prepared for the rules and regulations that are reasonable, and two, if anybody's been to the Obenshain building in the last 10 years, which is for those who don't know, it's the state party headquarters in Virginia, there are parts of it I'm not sure are safe anymore. Would you agree with that?
I agree with you, Congressman. I've been in many state party headquarters across the country, and, well, I don't need to say anymore. They're in rough shape.
But you would agree that having a building fund and a legal fund would both benefit the following of the law and benefit the state parties, even to a minimal extent of keeping their property in a better fashion.
Absolutely. There's no reason why you shouldn't allow the state parties to have these additional accounts. They're not being used for TV ads. They're not being used for anything that needs to be further regulated. And litigation has become a much bigger concern on both sides of the aisle. whether it's them being sued for something or needing to hire compliance attorneys. So I think it's absolutely a great idea.
I yield back. Thank you, Mr. Chairman. Appreciate it.
Gentleman yields back. The ranking member, Mr. Morelli, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank all of you for being here, for testifying, for your participation today and in the electoral process. In terms of full disclosure, I should say I'm a former county Democratic Party chairman. I served for 9 years, and much of, I think, what was said by the witnesses, I think we could put together in a bipartisan approach to addressing some of the things that you raised, which I think are reasonable. I would, however, since the bottom line rationale for the hearing was to talk about free speech and disclosure and transparency, I do want to focus on that. But before I do that, I want to just ask Ms. Dillon, did Joe Biden win the 2020 presidential election?
Joe Biden is the President of the United States, yes.
But that's not the question I asked you. Did he win the presidential election?
He won a deeply flawed election, yes, he's the president.
I'm sorry, I didn't hear that.
He won a deeply flawed election. He is the President of the United States.
So he won the election. Ms. Martin, did Joe Biden win the 2020 presidential election?
He did. He is the president.
Mr. Reamer, did I pronounce that right, sir? Did Joe Biden win the 2020 election?
Yes.
Professor Smith, did Joe
Yes.
Biden win the 2020 election?
Yes.
Mr. Spalding, did Joe Biden win the 2020 presidential election?
Yes, fair and square.
Thank you. Mr. Spalding, the Supreme Court observed in Buckley, safeguarding the ability of the citizenry to make informed choice among candidates for office is crucial. Can you expand on the value that transparency and disclosure requirements have in aiding the electorate? Because this is ultimately about giving the tools to voters to make informed decisions. So could you just expand upon that?
Absolutely. Thank you, Ranking Member Morelli. That's exactly what the court said in Citizens United, as I mentioned, at a provision of the opinion that was endorsed 8-1, that when they were going to declare this First Amendment right of corporations to spend unlimited amounts of money in politics, Justice Kennedy essentially wrote, don't worry about the corruption interest there because it will be disclosed. The electorate will be able to evaluate the strength of messages, will be able to evaluate who is speaking, and actually talked about shareholders being able to hold corporations accountable. I think he said something about how until today, a disclosure regime essentially hasn't existed to shine a light on politics, and it still hasn't existed. 13 years after the decision, our disclosure laws have not kept pace with how money is spent in elections, and it has deprived voters of their First Amendment interest in knowing who is speaking to them, in knowing who is behind the messages that they're seeing online. And the other thing I'll point out too is there are secret spenders who know where the money is, recipients of secret spending who know where that money is coming from. And look at that Ohio example with the former Ohio Speaker of the House who was indicted. He knew exactly where that $60 million was coming from. It was coming from a power company that was backing, in part, his election and in people to the state house that would support his role as Speaker and eventually as part of a $1 billion bailout for the power company.
Well, let me expand on that. The bill that has been referenced, the ACE Act, would loosen disclosure requirements. And in your opinion, the example you cited, would the enactment of the ACE Act make it more or less likely that the example you've cited could be replicated?
Well, given that the ACE Act is dealing with federal elections, it would absolutely curb the chance of that happening at the federal level. But there's provisions of this bill. I mean, Section 325, repeal requirement of persons making independent expenditures to report the identification of certain donors. Section 341, prohibit regulations on political contributions, directs the Securities and Exchange Commission to not finalize, issue, implement any rule, regulation, or other order regarding the disclosure of political contributions. That directly contravenes what Justice Kennedy wrote in Citizens United, which was about shareholders being able to hold their corporations accountable through disclosure. This bill would be a big step backward in that respect.
Thank you for that. I did note, and I'll, because my seconds are quickly ticking away, but Mr. Smith, you had indicated that it's not only trying to protect the home of the brave, but you said the home the meek and other, it seems to me that many of the people putting hundreds of millions of dollars or billions of dollars into dark money and trying to influence elections without disclosure are hardly would be termed the meek. I think, and I could certainly, and I just finished by saying, certainly some of the low-level disclosure, or the low-level amounts that you've talked about, I think could be raised. I think there's a way to reach this in a bipartisan consensus. But the real threat to American democracy remains large amounts of money being put into American elections without any disclosure and the presence of dark money. And I personally want to make sure that that does not happen. With that, I yield back, Mr. Chairman.
The gentleman yields back. The gentleman from Georgia, Mr. Loudermilk, is recognized for 5 minutes.
Well, thank you, Mr. Chairman. Thank you all for being here today. First question, Ms. Dillon. Are Americans who donate to nonprofit organizations receiving the protection they deserve under the law today?
Well, I think a lot of donors are deterred from making donations when they look at the lowest learner example. And indeed, even though protections for donor privacy date back to NAACP era and concerns by African Americans of hounding by their government, today it is donors across the board, but mostly conservatives, who are concerned that if they express their political speech through contributions to nonprofits that are disfavored by the government in power or state actors, what have you, they will be punished for their speech through audits, investigations, harassment, et cetera. And the last couple of decades in our country have provided many examples of that.
Well, I appreciate that, and it's interesting you brought up lowest learner. I think we're in about a decade now, 10 years since that was made public. And with that in mind, besides government intimidation, isn't there a real possibility that donor lists that feature the names, addresses, and sometimes contribution amounts might be leaked to the public?
Not only is there a possibility, we've seen this happen, and with the acceleration of mob-type behavior through social media, it can put donors at real risk when their privacy is not respected. And this should not be the case when donors are contributing to legitimate nonprofit ends. And so I think it is critical, and I say this as the CEO of a nonprofit, to encourage and protect core First Amendment speech through contributions to nonprofits, that donor privacy be respected.
Especially in this woke culture that we find ourselves, or cancel culture, I should say, where retribution has been and is taken on to people because of their political beliefs, their religious beliefs, their thoughts. That is totally outside of the scope of American ideas and principles, is that you do have a right, not only to free speech, but right to thoughts and beliefs. Our government and our laws are set up to punish bad behavior, not thought. And in an instance like the leak that you've described, that causes hundreds, if not thousands, of Americans to be harassed for the crime of giving money to groups that they agree with, is there not personal risk in that as well? I mean, we've seen incidents where people have lost their jobs because of something that they posted on social media.
Oh, absolutely. I'd say not only have people lost their jobs, they've lost job opportunities. They have been forced to retreat from their homes due to mob threats. This is a bipartisan problem, and so I think that everyone should have an interest in donor privacy for these reasons. And so cancel culture run amok, accelerated by social media and by the heavy hand of government acting in concert with social media, is a significant risk to First Amendment speech in the United States, both with respect to donations to nonprofits, as well as, I would say, simply people expressing their views, expressing their right to consume or participate in a free press, to gather together. Every aspect of the First Amendment is under threat through these types of issues that we're discussing here today.
And I've heard from constituents myself, they're afraid to get involved in politics, and this has just come about in the last 3 to 4 years, and especially donate because they're afraid that their name may be disclosed, even if they gave to an individual candidate. Not as much is what the government may do, but what others may do, and putting pressure on their employers. In fact, I know a firsthand account, a gentleman right now who has already lost a job because his identity was, in my opinion, illegally disclosed by the January 6th committee for doing nothing wrong, and he cannot get a job at this point. And so in this culture that we live in is to punish people who do not agree with you politically. That's really what it comes down to. And in your opinion, is the end goal of all this to ensure that these groups never receive funding again because of donor fear that their personal information might be disclosed to the public? Is that the end goal?
It is certainly a goal, and ironically, what we've seen in California, a liberal jurisdiction, is it actually has a very good law with respect to employment, which protects individuals from political retribution on the basis of their political viewpoints or associations. I think that that is a laudable statute that should actually be replicated in many other states. But at the end of the day, the use of the exposure of donor information poses a significant risk nationally to liberty and privacy.
And that information is used for intimidation. I yield back.
Thank you.
The gentleman yields back. Ms. Sewell is recognized for 5 minutes.
First, I'd like to thank our witnesses for their testimonies today. As a ranking member of the Election Subcommittee and as the author of the John Robert Lewis Voting Rights Advancement Act, ensuring that Americans have the resources they need to make well-informed decisions at the polls is something that I am deeply, deeply concerned about. Voting is a cornerstone of our democracy, and for far too long, states have placed barriers in front of the ballot box. According to a recent study by the Brennan Center, state lawmakers in at least 32 states pre-filed or introduced 150 restrictive voting bills. These bills create stricter voter ID laws, cut voting times, restrict registration, and purge voter rolls. The bills also make it harder for people of color, poor people, young people, disabled people, elderly people to have access to their right to vote. Campaign spending has swayed elections in the last 13 years by allowing secret donors to funnel over $1 billion into elections that are influencing the way voters vote and picking winners and losers. In 2014, Energy 2002, Arizona's biggest utility company, paid more than $10 million for attack ads that helped defeat consumer-oriented candidates for a seat on a state commission that oversees the state utilities. As a result, residents saw a grave price hike shortly after the new commission was established. Voters deserve transparency. I think all of us should be behind that, based on the facts and not on disinformation. Voters have a right to know who the secret funders are that may be influencing candidates' political interests. There is a common misconception, however, that by hiding dark money, we are helping to shield donors from some sort of harm or their privacy being invaded. And those that support that often use the NAACP versus Alabama case as a point to prove this point. The NAACP versus Alabama was a 1958 case. It was based on the fact that in 1956, the Alabama Secretary of State required the NAACP to disclose the names and addresses of all of its members in the state. Again, this is 1958. The NAACP refused to release those membership lists because they feared that members would be in danger of losing their lives. The Supreme Court agreed with NAACP because Black civil rights activists faced severe threats from raids of Ku Klux Klan members that included the church bombings, shooting up their houses, and shooting them as they rode on buses and in taxis. The NAACP versus Alabama, I believe, is not the blueprint for hiding information on who wealthy donors, special interest groups, and corporations are funneling money into campaigns behind the scenes. In fact, I'd like to move for unanimous consent, Mr. Chairman, to submit an article for the record. That article is, one of these things is not like the other. The NAACP versus Alabama is not a manual for powerful, wealthy spenders to pour unlimited secret money into our political process, end quote.
Without objection.
Thank you, sir. Mr. Spaulding, you spent your time in your testimony talking about the Citizens United case. And the Citizens United case, as it was decided, really has allowed, as you said, at least $3 out of every $10 in outside money since Citizens United can be traced to dark money. What impact does a deluge of undisclosed electoral funding have on the information available to voters, and why should this be safeguarded?
Thank you, Ms. Sewell. One, it crowds out and obfuscates who is speaking to voters. So they can't separate fact from fiction. They can't evaluate the message because they don't know who is speaking to them. It's unclear where their money is coming from. And I also think it really increases a lot of cynicism in politics. And people throw up their hands and they say, my voice doesn't matter. You know whose voice does matter? It's the corporation, the wealthy, special interests that are dumping unlimited amounts of money into our politics and hiding behind fake front groups and fake names. And so people throw up their hands and they sit out the next election and they say, my voice doesn't matter. And that is un-American.
I would agree. I yield back the balance of my time.
The gentlewoman yields back. Dr. Murphy from North Carolina is recognized for 5 minutes.
Thank you, Mr. Chairman. I tell you, everybody here, thank you all for coming. It's honestly embarrassing for the United States of America to have to be dealing with this. We're supposed to be the paragon of excellence with voting, and we're supposed to go into other countries and make sure that they do it right, and we just can't do it right in our own damn country. It's embarrassing. And I'm saying this for Republican and Democrat. This has no allegiance one side or the other. It's embarrassing. And so I appreciate what everybody's doing here as trying to keep free and fair elections. Every voice should be heard who wants to be heard. But there's also a thing called personal responsibility, getting up off your own derriere and making sure that you can do something. Let me just play a quick round robin about ask questions, and we'll go through. Should dead people be on voter rolls?
No.
Absolutely not.
No.
No.
All right, so good. No dead people. They're in heaven. They don't need to vote. Voter ID. Is voter ID, is it repressing the vote?
It is not.
No.
No, the data is clear that it's not.
Agree with Mr. Reimer.
It depends on the ID. No one opposes ID. What people
Is
oppose
voter
are
ID,
the types of ID.
is voter ID suppressing a vote?
What type
Yes or no? Let's stop the
Depends on the
lawyer-eyeing
ID. It's
question.
much more
It-
complicated.
If I
11% of
pull
the
out an
public lacks
ID,
the type of
yes or
ID.
no, you did this again, is it yes or no? Is voter ID suppressing the vote?
It depends on the ID. No one opposes voter ID. What people oppose are specific types
All right,
of ID.
I'm gonna take that as you don't agree.
Politicians are
All right,
requiring
next thing.
people that
All right.
many communities of color
Mr.
and
Spalding, I'm
voters
running this thing
disproportionately
right here.
lack.
Let me ask, since you're talkative, let me ask you a question. You said half of the people sat out the 2020 election, correct? Do you believe it's a person's personal responsibility to vote?
Yeah, I think it is everyone's freedom and responsibility to
Right,
make their voice
so
heard.
half the people voted, and so half the people said, I don't want to vote, and that's their personal responsibility. I agree with you that we should have everybody
I
vote,
appreciate
100%.
that. I appreciate that. I don't think that we know that 50% said, I don't want to vote.
Well-
That's where I might disagree.
Yeah, okay. So ballot harvesting, for example, do you agree with that?
Can you define ballot harvesting?
Going and having a kid walk through a neighborhood and pull on houses, here's your voter thing, I'll help you fill it out and I'll hand it in.
What if my
No, yes or no, with what you just asked my
I'm
example.
sorry, can you please repeat the hypo?
All right, a teenage kid that is paid to go and knock on doors and say, here's a ballot, I'll help you fill it out if you don't understand, and take it in and turn it in.
If the ballot is lawfully voted, wouldn't have a problem if a teenager, perhaps they, maybe
Okay.
they're 18 and they work for the post office. I don't have a problem with someone
All right,
taking a voted ballot from somebody who may be
What if they went through
homebound
nursing
and
homes?
wants to make their, sure, if you're in a nursing home, you have a
Okay, and you
right
don't
to
think
make
there's
your voice
anything that
heard.
could go wrong with that? Where that voter could be influenced?
What voter, by voting from
No,
home?
some person coming around and saying, here, you vote this way, and they couldn't be influenced.
Well, there's laws against voter intimidation. I
No,
mean,
I'm
that's
just saying,
illegal.
do you think there's anything that could go wrong?
It's hard,
It's ripe for fraud. It's ripe
that's
for
just
fraud.
not, but that's just isn't, right, that's just not,
It's ripe for fraud. I mean, my gosh, if somebody, the American public oftentimes doesn't have any clue as to what's going on.
I think we
All right,
should-
let me ask on the thing, Mr. Smith, I was just informed of this. I'm not an attorney. I'm just a dumb surgeon, so I'm just trying to figure this stuff out. In the American Confidence in Elections Act, there's a provision to require unanimous consent of the FEC commission members in order to refuse to defend actions against the commission. So in other words, they're trying to be sued. It's my understanding that the commission was often deadlocked, 3-3, when voting on the FEC could even defend itself in cases. Based on your experience with campaign law and litigation, can you speak to and share your thoughts as to why this provision would be needed? Why would we prevent the FEC from trying to defend itself if it was being sued?
Sure. I would begin by noting that I don't think the FEC is often deadlocked. I think that's vastly overstated, but that's sort of a whole nother issue, and it does deadlock, so you're right there. At times, there's a 3-3
deadlocks
vote.
as to whether they could defend
There's a 3-3
themselves?
vote not to investigate or to find, not to find a reason to believe that a person has violated the law.
Okay.
What has been happening on the commission in recent years is typically after the commission votes not to proceed to enforcement or not to fine a party, right? If the vote comes 3-3 and you need a 4-vote bipartisan majority to carry on. So if the commission goes 3-3, the commissioners who voted not to proceed are the controlling group. That's been recognized by the court. Their decision controls the commission. But what has happened in recent years is that Democrats on the commission have in some cases refused to vote to close the file, which is what is necessary in order to notify the parties, hey, we've exonerated you, or at least we're not going to pursue this any further. So the parties don't even know that the FEC is no longer pursuing a complaint against them. Then what happens is the private group, that typically a partisan group such as Crew or something like that, that has brought the complaint, can then go into court and sue the FEC for not acting on the complaint, even though the FEC actually has.
All right, well, I think we're
going
going to have to wrap up. We're getting
Okay.
donged by the chairman.
So we need, and what happens then is that the Democrats then refuse to allow the commission to appear in court to explain what it has done, thus trying to trigger a default
All
judgment.
right, thank you for your reply. Thank you. Mr. Chairman, I'll yield back.
The gentleman yields back. Ms. Torres is recognized for 5 minutes.
Thank you. Mr. Spalding, since the 2020 election, the country has seen a wave of restrictive voting laws, many of which it has now been reported were backed by billionaires-funded groups that were trying to suppress the votes of people whose opinions they disagree with. They're doing this behind closed doors and with clear political intentions. For example, the Heritage Action, an arm of the Heritage Foundation, is reportedly spending tens of millions of dollars pushing for restrictive voting laws. The ability of every eligible voter to cast a ballot is a fundamental principle of democracy. You know, January 6th was a really dark day in Americans' history. When folks in my community say how brave we were to go back and finish our job and certify the election that had been already certified by 50 states, I push back and I say the bravery did not come from the members casting a vote to certify the election. The bravery comes, and defending our democracy comes from every voter being able to cast their vote and having the courage to stand in line for 6 hours, to have the courage to pass by an armed member of their community who is standing there in an effort to stop them from voting. That's the bravery of in the decency of democracy that we need to uphold. What we do here is the easiest part of that. But we do have a responsibility to ensure that the people who are funding campaigns disclose themselves so that the people that are paying attention, whether it is to a mailer that comes in the mailbox, a yard sign that has been posted, a TV commercial, whatever campaign paraphernalia is posted out there in the community, the voters have a right to know who paid for that. And they have a right to know who paid for that because America has a dark past. in preventing people who they don't agree with from voting. So the ability of every eligible voter to cast a ballot, again, is fundamental. Have we experienced a wave of election-related conspiracy theories and misinformation, Mr. Spalding?
Absolutely. We've seen a wave of disinformation, misinformation that has deeply, deeply poisoned our democracy. And as you brought up, January 6th, when a former president, relying on a big lie, summoned people to Washington, incited an insurrection, turned them to march up here and ransack the people's house in an attempt, we want to talk about cancel culture, in an attempt to cancel the votes of more than 100 million Americans. That was inspired by a big lie and disinformation that to this day, including last evening, up until the second that I'm sitting here, continues to poison our democracy.
And yet we have yet to see justice on that case. I mean, we've seen many gullible people go to prison and are going to do some hard time for their responsibility and their actions on that day. Assaulting our police officers, using the American flag, their attempt to kidnap members of Congress, their attempt to hang Vice President Pence. Has that fed a backlash against an increased voter participation when they see those images?
It has. I think people throw up their hands. But I do think that it has also led to determination. There are hundreds of bills after 2020 that were introduced in state houses across the country to make it harder to vote. And at the same time, we are seeing people stand up and say, that's not how we run our democracy in this country. We're going to expand access to the ballot box. We're going to do whatever we can to lift up every voice in our democracy and make sure it's heard.
Thank you, and I yield back.
The gentlewoman yields back. Ms. Lee of Florida is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Smith, I would like to return to your testimony and some of the questions that Dr. Murphy was covering with you. When that testimony left off, you were discussing the subject of the FEC failing to close files, even after a determination not to pursue a complaint, and after deciding not to find a violation. Could you go back to that and elaborate on why that is significant, why it matters?
Yes, thank you, Councilwoman, for the opportunity. So, as I was explaining, the FEC sometimes reaches a 3-3 vote not to investigate or not to find a party guilty of a violation. Again, it needs a bipartisan majority, and that's one of the protections that's built into the FEC. Other people have been trying to destroy that by creating a partisan majority, but that's another issue. So the commission votes 3-3 not to proceed. But then the Democratic commissioners have refused to vote to close the file, meaning nobody's notified of their decision. Then eventually the group that brought the complaint has a statutory right to sue the FEC for inaction. The FEC has acted, but nobody knows it. So they sue, and then the Democratic commissioners have voted not to allow the FEC to defend itself in court, so that it can't go up and defend the decision of the controlling commissioners there. So you get a default judgment against the commission, which essentially then enacts the theory of the law and the belief in the facts that the complaining party has, rather than having the commission do it.
So
this
right
is an
there, I
intentional-
want to be sure we make this point very clear for everyone, including some who maybe haven't spent as much time in the courtrooms as others. Would you explain, please, what is a default judgment? So if the FEC is sued, fails to show up, fails to respond to a complaint, the court enters a default judgment. Would you explain, please, the significance of that and what it means?
Yeah, I mean, a default judgment essentially is the court saying nobody showed up to defend, so we take the allegations basically in the legal position of the plaintiff as correct. And so what this does is it has the effect of farming out the interpretation of federal election law to groups on the political left that file complaints with the FEC and get the 3 Democratic commissioners to go along and refuse to allow the FEC to even explain its reasoning, and that it has in fact acted. It's really a fraud on the court.
And in that circumstance, then, the FEC is not disputing filing an answer to the complaint or putting anything into the court record that would contradict the allegations in the plaintiff's lawsuit, correct?
Exactly, it doesn't show up.
Now, and isn't there also a potential consequence related to sanctions, attorney's fees, or other things for the failure to respond in the case of an action being filed?
There can be.
Moving on to a different subject, going back to your prior testimony, you touched on the subject of IRS official Lois Lerner and the issues attendant with her. Will you talk a bit about the consent decree that the IRS entered with the Tea Party groups?
Sure. Eventually, the IRS did enter a consent decree about 4 years after the scandal broke. In it, the IRS admitted that its treatment of conservative organizations during the tax-exempt determination process, including screening their applications based on their names and policies provisions, subjecting those applications to heightened scrutiny and inordinate delays, and demanding of some plaintiffs information that the U.S. Treasury Inspector General for Tax Administration had determined was unnecessary to the determination of proper tax status, was nonetheless used to delay status here.
As we sit here today, all these years later, do you feel like we are still vulnerable to such action occurring again?
We clearly are. As has been pointed out, Congress has blocked the IRS from moving forward in this direction, but it's been on an ad hoc basis on a sort of a year-by-year device. And really what we need to do is get the IRS out of enforcing campaign finance law. The reason it got into this was precisely because the bipartisan FEC was not engaging in enough partisanship. So the IRS is under control of the president. The president at the time made a number of statements about how these groups were destroying America and they were a threat to democracy and all this kind of thing. And the IRS picked up the cue. It didn't have a direct order, but they're not stupid. They picked up the cue, who will free me of these troublesome priests, and they began harassing these conservative organizations. And there's some evidence that it cost Republicans possibly as many as 5 to 8 million votes in the 2012 presidential election.
And what action, if any, or do you think Congress could take, or what legislation could be enacted to prevent further abuses of this nature?
It gets a little bit complex, but again, basically it says that the FEC, the bipartisan FEC, which is supposed to interpret campaign finance law, will determine whether a group is engaging in political activity under the law, and the IRS, it merely administers the tax side of things.
All right. Thank you, sir. Mr. Chairman, I yield back.
The gentlewoman yields back. Mr. De-Esposito is now recognized for 5 minutes.
Thank you, Mr. Chairman, and good morning, everyone. Ms. Dillon, over a year ago, the Department of Homeland Security established a Disinformation Governance Board charged with, quote, review questions of privacy and civil liberty for online content, close quote. This board, fortunately, was short-lived and dissolved in August of 2022. I have a few questions based on the governance board. The first is, should the federal government be in the business of censoring political speech?
Absolutely not.
Second is, I'm pretty sure I know the answer to it, but just to get it on the record, and what about big tech? Should they be in the business of censoring any political speech?
I believe that, of course, corporations have their own speech rights, but when you come to a consumer platform like this, I do believe that the law should be expanded to allow protections, a bill of rights, if you will, for users of social media, because today they seem to be the consumers with the least rights in any industry in America.
Yeah. And I guess the final question is probably the one as to why we're actually here today. And what do you believe, what impact do you believe censorship has of political speech in both the online, the platforms, as well as other censorship? What is its overall effect on general elections?
Well, we can take the 2020 election as an example. The use of government funds and government coercion hand in hand with regulated industries, that is the social media companies, had a tremendous impact on citizens' ability that their speech was not going to be punished by the government. And we saw hundreds, perhaps thousands, just in California alone, who had their posts or their speech about the 2020 election, which is, of course, core protected political speech, removed. This has caused many of those citizens to believe that their voice no longer matters. It deters them from voting. It certainly deters them from speaking. It deters their friends from speaking as well, and this is un-American. And so I think that the First Amendment is the First Amendment for a reason. It is the fundamental premise on which we Americans act. It is a beacon for the rest of the world as well. And so when in America, our government works hand in hand with corporations to suppress speech, I believe that violates the First Amendment. And, courts have been reluctant to recognize that to date due to an outdated Communications Decency Act, Section 230, that is within the power of Congress to fix, and I urge you to do that. But beyond that, even citizens who don't speak on social media are afraid that they'll be punished at work, that they'll be hounded by a mob, that they'll suffer physical consequences for speaking. And so censorship is antithetical to freedom, and the antidote to speech that you don't like is more speech. And this is a fundamental premise of the First Amendment.
Thank you. Thank you for your work. Thank you for being here today. And I think the most important part of your answer was the fact that it's un-American. So thank you. Mr. Chairman, I yield back.
The gentleman yields back. Mr. Sarbanes is recognized for 5 minutes. We got it?
Thank you, Mr. Chairman, for the opportunity to weigh in on the committee. I want to talk a little bit about campaign finance in the context of how we equip.
The gentleman will yield just for a minute for tech support. I just want to make sure those viewing online are able to hear you. Let's take 1 second here for tech support.
How about now?
Much better.
Thank you, Mr. Chairman, for the opportunity to weigh in on the committee. And I wanted to take the opportunity to talk a little bit about another dimension of campaign finance. There was an allusion to it earlier, but this is the idea of empowering small donors so their voices can be heard, because oftentimes the average citizen out there feels like they cannot compete against deep-pocketed donors, against the super PACs and so forth. They want to be on the field of their democracy. They want to feel like they have some power within their own democracy. And one of the proposals that was included in the Freedom to Vote Act was to establish a small donor matching system. So if a small donor gave $20, $50, it would be a corresponding match, like a multiple match. It would come in, lift that up, and allow them to feel like they're the ones that are supporting campaigns, and frankly, they're the ones to which the candidates and members of Congress ought to be accountable. The evidence from this being implemented and tried across the country at the state level and the local level is when you do that, people feel much more invested in their democracy. They feel like they're the ones that own the outcomes, not some shadowy, dark money figure that's hidden behind the curtain. So it's a really important dimension. Having said that, I want to try and nip in the bud before it gets distorted, this notion that the fund that would provide these matching dollars will be a taxpayer fund. In fact, if you look at the language of the Freedom to Vote Act, and I think there was a reference to the bill earlier that maybe missed this, it explicitly says, with respect to the fund that would provide these matching dollars, quote, "No taxpayer funds may be deposited into the fund." And that same no taxpayer fund requirement actually applies to this entire state election assistance fund that would cover all kinds of innovations that could happen at the state level. So we were very intentional about making sure that taxpayers would not be on the hook. Well, the question is, well, then where are you going to get the funds? We came up with an elegant proposal on that, and that is to put a very tiny surcharge on settlements with high-end tax cheats and corporate lawbreakers. So let me give you an example. In 2019, Facebook was ordered to pay approximately $5 billion to the federal government because they mishandled users' personal information. So you take a tiny little surcharge on that, you put it into the fund. In 2017, Volkswagen, remember this, paid a $4.3 billion fine to the federal government for cheating on diesel emission tests. So you take a tiny piece of that, you put it into the fund. So this is how you would actually resource this ability of average citizens to get their voice amplified. And I just wanted to put that on the record because it seems that there's some misunderstanding about where the dollars come to support this matching effort. And we were very explicit, will continue to be, that not $1 of taxpayer money will go towards that purpose. Mr. Spalding, I don't have a lot of time. I got 30 seconds. Speak to me quickly about why it's so important for the average person who wants their voice to be heard to know that big money is having to be accountable in terms of disclosure and transparency.
People want to be heard, and when they see that so much of the money that is funding our elections is coming from such a, as I mentioned in my statement, such a tiny, unrepresentative segment of the population. You know, I was looking at, we've talked a lot about the political parties and contribution limits. One person, one donor could give to the political party committees in one election cycle up to $2 million, a $2 million check. And everyday Americans are saying, what about my voice? My voice has a role to play here too.
Thank you, Mr. Chairman.
Thank you very much. We appreciate you coming to House Administration, the most important committee in the House, as you well know, since you joined us today. Appreciate your testimony. Yield back. Mr. Kerry is now recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank the witnesses for your testimony today. I do want to, I'm going to talk a little bit about, or Mr. Reamer, I want to focus a little bit more on the, as your role with the RSC, your experience there. And I kind of want to, if we could, maybe, I don't think we were doing the same type of position back in 1976, but what was the impetus behind changing the amount, the donations back in 1976? And then when McCain-Feingold was enacted, why was the limit set to what it was? And was there ever any discussion at that time to raise it with inflation?
It's a great question, Congressman, and I'm not an expert on the legislative history of McCain-Feingold. What I do know is that for some reason, the limits were indexed for inflation for everybody but PACs and the state and local parties. I think for PACs now, that's largely a non-issue because we have super PACs and I think PACs have waned in their influence. But for state parties, I have not seen, and I actually, in researching for this hearing, tried to find some rationale for why they would exclude state parties, and maybe Professor Smith knows. But it very well could have been an oversight. I do think overall McCain-Feingold was trying to eliminate what was known as soft money, which was money flowing into the parties that was unregulated. And perhaps that was it. But that doesn't make any sense because they were federal limits, and all that money is disclosed, and all the money that's raised or spent is disclosed. So I'm honestly not sure.
Well, let me ask you, Professor Smith, do you have any historical reference to that?
Just a touch more. Yeah, the state party provisions in McCain-Feingold were basically kind of last-minute sorts of things. There was a concern that, oh my gosh, we're putting all these new limits on the national parties and that sort of thing. And, oh, now what will happen? Well, state parties can influence elections for federal office, so maybe we'll try to control them as well. And I just don't think there was much thought given to it. And like on the indexing side, that was a last-minute compromise that worked primarily at that time just on donations to candidate campaigns. So it was just one of those things that was an afterthought because the goal of McCain-Feingold was to basically reduce the amount of political speech. So they weren't thinking about trying to help state parties.
And to that, Mr. Reamer, I'm going to just say again, why is it so important? I have my answer, but I'm going to defer to you on this. Why is it so important that we have, both on the Republican and the Democratic side, why is it so important that we have strong state parties?
Absolutely. There's philosophical reasons, and I think there's concrete reasons. I think, let's go more practical. One, they recruit, nominate, and elect our candidates, and that goes down from school board or county council, let's say, all the way up to president. State parties have an integral role in electing delegates that go to the National Convention, who ultimately select the next leader of our country. And so in many ways, they're sort of the farm team as well. I'm sure lots of members on this committee that came up through the local party system. And so it's incredibly important. And I think another thing is we're talking about all these outside groups and super PACs and everything else, but 50 years from now, that super PAC is probably not going to exist. And 50 years from now, that state party is going to exist. So it's permanent. It's always there, and it's not going away.
Thank you, Mr. Raymer, and I would agree with my colleague from Virginia that while the party may still be there, some of our buildings may not be. But let me address you, Mr. Smith, on this. What are some changes you think could strengthen the state and local parties? What are some changes to the laws that you think could strengthen both the state and the local parties?
Well, I appreciate you asking me. It might actually be a better question for Mr. Reimer, but I would say the biggest thing is that currently there's this provision called Levin funds, and local parties are prohibited from engaging in communications that might have the incidental effect of helping federal candidates for office. And it just creates a colossal regulatory burden for state parties to figure out what they can do and to raise and spend money for their own state and local races. If they spend money in their state and local races, but it might influence a federal race, and it will because federal candidates are on the ballot, they get subject to all these regulations.
Mr. Chairman, I want to again thank the witnesses, all the witnesses for your testimony today. It was very insightful. And Mr. Chairman, I yield back.
The gentleman yields back. I now recognize myself for 5 minutes for the purpose of asking questions. Ms. Perry Martin, do you know when the federal government pays Social Security, does that come out of the U.S. Treasury?
I don't believe so.
So if a check was cut to build a road or a bridge in the United States, or fund our military, or pay for the men and women who are wearing the United States military uniform, that come from the United States Treasury?
I actually don't know the answer.
It does.
Okay.
So it come from the United States Treasury. And under the Democrats' H.R. 1 from last Congress, where they would take federal dollars and put it in politicians' reelection campaigns, would that come from the U.S. Treasury?
It would, yes.
It would come from the U.S. Treasury. So it all come from the same pile. So when we see the Democrats' bill from last Congress that every Democrat member voted for that puts federal dollars into politicians' reelection campaigns, it comes from the U.S. Treasury, the same U.S. Treasury that pays Social Security. Is that accurate?
Yes, it does.
I think that's important to know. Let me shift gears to you, Harmeet Dillon, if I can. When we traditionally think about free speech problems, we think about government censorship. But today, we see government working hand in glove with private businesses to censor speech. Ms. Dillon, based on your litigation experience, is it unprecedented for the American government to reach into private organizations to censor American speech?
Well, I don't know what happened in prior days, but I can say that the advent of social media has made speech a multi-billion, even trillion-dollar corporate endeavor, which is a good thing in a way. It has actually allowed many citizens whose voices never would have been heard by people in different states or around the world to speak. But that is only true if they're allowed to speak and be heard, if they're not being censored by the heavy hand of the government. And so today, the impact of government cooperation with liberal organizations and liberal executives at big tech companies in San Francisco has had a negative impact on speech in America.
Thank you. Let me shift gears slightly. In the 2020 election, we saw jurisdictions, including in my state of Wisconsin, municipal government jurisdictions accept private funding for elections, commonly referred to as Zuckerbucks. And again in 2022, we saw a similar pattern of private funding for elections, and in particular in the city of Milwaukee. Milwaukee Votes 2022 campaign again took private funding. Could you comment how Zuckerbucks influenced the 2020 election?
Well, absolutely, and you see, in addition to the states you mentioned, Pennsylvania, Georgia specifically, and CEIR used its funding to embed individuals in county election operations.
And how did it impact the election?
Well, those employees turned out to vote more in high-density urban areas, that is, Democrat jurisdictions. And so the impact was tens of thousands of votes in swing states that would otherwise not have been cast, being cast in a partisan fashion, and
So
that's the risk.
in your opinion, it had a partisan impact on the election. Is that accurate?
Absolutely, in
And
swing
so,
states.
So yes, it is. So should non-government, in your professional opinion, should non-government entities that provide funding for elections be able to receive tax-deductible contributions?
Absolutely not. Zuckerbuck should be banned, and certainly these activities, if they were allowed, not be tax deductible.
Ms. Perry Martin, do you think they should also not be tax-deductible donations?
I do believe that, yes, and I think a lot of the states have, there's 25 states that have already passed this. State legislatures have recognized this problem.
So half the states have recognized this and successfully blocked it, half the states have not. And including my state of Wisconsin has room for improvement here. Can you comment, Ms. Martin, about how we could improve our campaign finance system for parties and candidates to make it more transparent for voters?
That is a very, very good question. Right now, there are so many provisions of our campaign finance law that are overly complicated and honestly don't make a lot of sense. Modernizing and simplifying certain provisions of the law would make campaign finance laws more transparent for voters. For example, the limit on party-coordinated expenditures. Voters know that parties exist to promote candidates and political philosophies they espouse. It doesn't make any sense to have this limited amount of money that they can spend.
Thank you very much. I want to jump to you if I can, Mr. Spalding, with the final minute that I have here. Are you employed by Common Cause?
Yes.
And do you know the tax status of your employer, Common Cause?
Well, we have a 501c4 and a 501c3.
Well, are you employed by both
Actually,
the 501c4
I'm actually
and the 501c3?
I'm employed by the 501c3, Common Cause Education.
You're employed by the 501c3,
Correct.
Not the 501c4.
Correct.
Okay. Under the Disclose Act passed out of the House last Congress, strongly supported, I believe, by President Biden, would have required Common Cause to reveal its top donors, contrary to privacy protections under current law. Is that accurate?
Did you say the Disclose Act?
Yes, sir.
No, it is not accurate.
The Disclose Act would not require the disclosure.
The Disclose Act would require organizations that spend $10,000 on certain campaign-related disbursements like IEs, electioneering communications, we're a nonpartisan organization. We don't endorse candidates.
And Common Cause is not engaged in that activity.
Neither Common Cause nor Common Cause Education Fund endorse candidates. We don't do campaign-related work. We're a nonpartisan advocacy organization.
Very good. Thank you. Recognizing the time, I'm gonna yield back and recognize the gentleman who's joined our committee from the great state of Louisiana, Mr. Johnson, for 5 minutes.
Thank you so much, Mr. Chairman, for inviting me to participate. I would be so blessed to be on your committee, but I serve on House Judiciary, on Armed Services, and on the Select Committee on the Weaponization of the Federal Government. Before I got to Congress, I spent 20 years in the courts defending free speech, religious freedom, and the like, so this is an issue that's near and dear to my heart, and it's also near and dear to the hearts of our constituents. When I'm back home in my district holding town halls, probably the first or second question I get in every open forum is, can we trust our election system? And this is no game, and we all know that it's one of the most pressing issues that we have because America's trust in our institutions is wavering. It's at all-time lows, and if we don't have this, you can't maintain a constitutional republic. So here's the problem that our constituents can see with their own eyes, that it's become common practice now for various groups and even federal agencies to pursue retribution against Americans for simply exercising their First Amendment right to participate in the political process. In the Weaponization Committee, we have uncovered alarming information about, for example, the IRS targeting conservative groups, the name and shame tactics of the radical left. We know that none other than the FBI itself quite literally colluded with the social media platforms during the last 2 election cycles to censor and silence viewpoints they disagreed with. This is un-American activity, and it's deeply concerning. There's also a lot of confusion about the law. So let me just ask Mr. Smith first. For about a half century, the Supreme Court has been crystal clear that spending money in the context of political activities qualifies as protected speech under the First Amendment. Can you briefly describe, just for the record today, why that is?
Sure, it's one of those things, if you ask the average person, is money speech? Of course, they say no, and the Supreme Court doesn't say that money is speech. As you put it, they say that spending money affects speech. So let's imagine we said, well, the New York Times can't spend more than $3,300 a year to publish, which is the amount, an individual can give to a campaign. It would be a very small newspaper very, very quickly. To communicate with a large audience, you have to spend money. Or let's suppose that we said, well, you have freedom of religion, but you can't spend any money to build a church or buy hymnals or pay a pastor. Clearly, that would impact the First Amendment freedom of religion. It's the same thing with speech.
Yeah, because a candidate or an advocacy group obviously can't get their message out without spending money. This is the way it works. That's reality. And isn't it true also that the Supreme Court has also said that the only constitutional basis for restricting money in politics is to prevent a quid pro corruption or the appearance of that? Isn't that right?
That's correct. And sometimes people say that the appearance of corruption serves just anything people think is corrupt about the government. They spend too much money, but it's not. By corruption, the court was very clear, it meant the appearance of, as you put it, quid pro quo corruption.
And every, we've had justices on the right and the left acknowledge this and agree with it, embrace it. Every election cycle, we hear about the pernicious effects of Citizens United. It's like a curse word now on the left. But didn't that decision simply reaffirm basic First Amendment law that corporations have a First Amendment right to speak on political issues?
I agree, it did. And I also want to point out that on the disclosure side, that dealt only with express advocacy of election or defeat of candidates. That was the issue there. So that was not some broad license to pass anything you want to call disclosure and say you can interfere with people's privacy.
And here's an interesting footnote. Isn't it true that during the Citizens United oral argument, the Obama administration actually argued before the Supreme Court that it had the authority to ban books, movies, and speech if it was made close to an election?
Yes, even one line.
Ms. Dillon, I wish I had more time, but let me ask you real quickly. Could you briefly describe some of the litigation that you've been involved in that relates to the government telling private businesses to censor viewpoints the government sees as wrong or dangerous?
Well, one example, thank you for your question. One example is the case of Rogan O'Hanley, who was banned from social media for questioning the number of votes that President Biden received, and even posting a photograph of barbed wire around the Capitol, and highlighting the irregularities, multiple irregularities in the 2020 election. And he is just one of hundreds that we know of in California, and we've since learned that there were thousands nationally. And I think the most chilling thing to me was learning that the Federal Bureau of Investigation, which comes from a government that regulates these companies. So a company is not free to simply say yes or no or take a meeting with the FBI when the FBI asks you to do something. And so that chilling effect, I think, has been highlighted thanks to a change in control at Twitter. Without the change in control at Twitter, we never would have learned the extent to which our federal government is threatening the freedom of American citizens to speak freely on an election.
Exactly right. Unfortunately, I'm out of time. I yield back.
Thank you very much. We appreciate you being here, Mr. Johnson. I know sometimes judiciary doesn't have the robust intellectual debates that we get to have in the Committee on House Administration, so you're welcome to join us anytime.
I did not say that.
Appreciate you being here. I now recognize the ranking member, Mr. Morelli, for 2 minutes for closing remarks.
Yeah, thank you, Mr. Chairman, and thank you for all the witnesses for joining us this morning. Supreme Court has repeatedly stated that disclosure requirements are essential to safeguarding the ability of the citizenry to make informed choices, and House Democrats will continue to combat the rampant use of dark money with legislation like the Freedom to Vote Act, Disclose Act, and other measures to strengthen our campaign finance laws. And I just, in my last moments, just want to ask for unanimous consent to enter into the record a report published by the former chair of this committee, Congresswoman Zoe Lofgren, who reviewed public social media posts by members of the House who were sworn in January 21 and who voted to overturn the 2020 election. These are posts on Twitter, and I note that they were allowed to post on Twitter, even though they were posting what essentially were untruths, and so they're on Twitter. I just want to make that point. I also want to just note, Twitter's a private company. They're able to post whatever they choose to post. So I'm not aware that the Supreme Court has ever ruled that they're bound to observe and post everyone or to validate anyone else who has the freedom to speak out. So I also ask unanimous consent to enter into the record the decision in protectmarriage.com versus Bowen, finding that the groups involved in Proposition 8 were not small persecuted groups, but part of what they call in the decision a massive movement. And with that, again, Mr. Chair, thank you for bringing everyone together. I think this is an important topic, and we look forward to continuing to work together on this. So thank you. I yield back.
The gentleman yields back. Without objection, both will be entered into the record. I will note, I believe, the first document was produced in the personal office of Ms. Lofgren, not from the committee, if that's accurate. Appreciate all of our witnesses being here today. I think we're having a really good conversation about how we make it easy to vote, hard to cheat, about how we protect individuals' First Amendment rights. And I think it's really important that we're holding this hearing on the 10th anniversary, or near the 10th anniversary, almost to the day of the Lois Lerner debacle. We need to make sure we're protecting the freedom of speech here in the United States of America. I think the ACE Act moves us forward in that direction. I appreciate everyone's time today. And with that, the committee, let me flip back, actually. For the formal work. Members of the committee may have some additional questions for you. We ask that you please respond to those questions in writing. And pursuant to paragraph C of Rule 14 of the Rules of the Committee, I hereby appoint Caleb Hayes, a member of my staff, as parliamentarian of the committee. I seek unanimous consent. I seek unanimous consent that, I'll pause. Is there a letter? Just being so, thank you. I'll seek unanimous consent. Apologize for my own tech support here. Seek unanimous consent that the letter be entered into the official record. A copy of the letter was made available to all committee members. Without objection, each member will have 5 legislative days to insert additional materials into the record or to revise and extend their remarks. There's no further business. I thank the members for their participation. Without objection, the committee stands adjourned.